Okay, we're ready to get started. Hello, everybody. Thank you for coming out on a cold evening with a little bit of snow earlier today. It's not snowing at the moment, and hopefully it'll hold off for everybody's trip home. And welcome everybody watching on the live stream as well. My name is Jim Lakely. I'm the Director of Communications here at the Heartland Institute, and welcome to what is going to be our last public policy event of 2017, which is kind of hard to believe, isn't it? Year's getting late already. Let me tell you a little bit about Heartland for the new people in the room and also watching online. Heartland was founded in 1984 in Chicago by a group of individuals led by our founder, David Padden. They met regularly to discuss the value of free markets and the importance of advancing and protecting individual liberty, and not just among fellow policy wonks in Washington, D.C., or to members of Congress, but for the people here in the heartland of America. And specifically, our target would be state legislators, who, for instance, might not think it's a good idea to make entrepreneurs need to spend a lot of money and time jumping through bureaucratic hoops before they can go into business, all in the name of some kind of sense of public safety, which doesn't really amount to much. And our speaker tonight, who you're all here to see, will get into that, as that is her topic. And if you like what you see tonight, whether here in person or watching online, I encourage you to look around at our website, heartland.org. Check out our blog, which is called The Freedom Pub. You can also check out our daily podcast on iTunes. I was happy to interview our guest earlier this afternoon for the podcast. We're on pace for more than 2 million downloads in the calendar year of 2017 for that podcast. So hear for yourself why they're so popular. And you can also check out our YouTube page, Heartland Tube. And you'll see this presentation and all the presentations we've had this year and the last couple of years here in the Andrew Breitbart Freedom Center. And you're going to see a lot that I think you're going to enjoy. And if advancing freedom is important to you, I would urge you to join us, join the Heartland Institute in helping advance our mission of free markets and individual liberty and promoting those ideas to the world. We'd love to have your support so we can keep informing the public and elected officials on those important topics and protecting our liberty. There are boxes on the tables here if you'd like to donate right now. That would be just fine. Or you can also come up to any employee of the Heartland Institute who have name tags just like this one. Or you can come up to Joseph Bast, our CEO, who's sitting right over here. He's waving to you, so you can know who he is. Tim Hulskamp, our president, is here in the building. He just slipped out, I believe. You can also talk to him. I call him our new president, but it's been, 6 months now, I think, almost 6 months. It's kind of like saying Happy New Year. When do you stop saying that? February? I don't know. Maybe I'll stop saying new president around sometime early 2018. And you can also come up to me as well. Thanks for your attention on those housekeeping items. And now it's my pleasure to introduce our guest speaker for tonight, Anastasia Boden. She's an attorney in the Pacific Legal Foundation's Economic Liberty Project, where she challenges anti-competitive licensing laws and laws that restrict freedom of speech. Her practice largely consists of representing entrepreneurs and small businesses who find themselves in a bureaucratic nightmare when simply trying to earn an honest living. Anastasia has represented moving and limousine and shuttle companies yearning to serve consumers across the country, achieving legislative reform in Montana, Pennsylvania, and West Virginia, and hopefully coming to a state near you. In addition to litigating, Anastasia testifies before legislatures on the impact of occupational licensing on entrepreneurship. Her writings on all matters of law and liberty have been featured in the Washington Post, the Chicago Tribune, Forbes, and other national publications. And in 2015, Anastasia was selected for the prestigious Claremont Institute's John Marshall Fellowship. And she's here tonight at the Heartland Institute's Andrew Breitbart Freedom Center to talk about the constitutional underpinnings of economic liberty, current threats to free enterprise, and pending lawsuits and repeal bills aimed at restoring Americans' precious right to earn a living as they choose. Ladies and gentlemen, please welcome to the stage Anastasia Boden.
Good evening, everyone, and thank you to Heartland for having me for their last event of the year. I hope they've saved the best for last, or at least it's the best that is relating to occupational licensing, even if it is the only one. My name is Anastasia Boden, and I'm an attorney for the Pacific Legal Foundation. Essentially, I get paid to sue the government when they violate your constitutional rights. So business is good. I'm here tonight to talk about what was once called the most precious liberty that man possesses, and that's the right to put one's faculties to productive use and to earn a living for oneself and one's family. Most people assume that if you work hard and if you work well, that should be good enough to go into business or to get a job. In fact, it's exactly how most people would describe the American dream. But not so. Nowadays, nearly a third of Americans need to navigate a tangled web of regulations and overcome substantial obstacles in order to obtain government permission, that is, an occupational license, before going to work. And it's not just doctors or lawyers or professionals that we traditionally associate with licensure that need a license. Instead, it's dog sitters, florists, physical trainers, masseuses, makeup artists, my personal favorite, hair shampooers, unarmed security guards, upholsterers, auctioneers, taxidermists, bartenders, and more all need a license in some states before going to work. And the burdens of getting these licenses can be substantial. On average, it takes 248 days of training, $130, and passing 2 exams to get a license to shampoo hair. Now, shampooing hair is something that most of us do regularly in our own homes without incident and without government permission. And it's 7 times the average amount of training needed to be an EMT. Something is seriously awry. In the 4 states that require licensure for interior design, it takes $1,260 to get a license and 2,200 calendar days of training and experience. That's to decorate homes. To be an athletic trainer, which is licensed in 49 states, it takes $72 and 1,500 days of training. Again, by contrast, on average, the license to get an EMT requires just $100 and just 34 days of training and experience. And even where licensure isn't outright required, there are sometimes restrictions that serve as anti-competitive barriers to earn a living. So one of the most prevalent kinds of restrictions are restrictions on what you can call yourself, the self-titling laws. So even those states where you can practice as an interior designer without a government permission slip, in some states you can't call yourself an interior designer unless you get a license. So it's perfectly legal to do it, you just can't tell anybody you do it. Because licensure is often required in low to moderate income occupations, often it will be the people who need economic opportunity the most that are hit hardest. Licensing occurs in professions that, in theory, should require few skills and little capital to enter, and thus present a good opportunity for people who need a quick leg up. Moving companies come to mind. One would think that purchasing a big truck and spray painting your name on the side of it, having some knowledge of the city, some brawn, and obtaining the proper insurance would be good enough to start a moving company. But licensure puts up barriers to these roads to economic opportunity. And by increasing the entry cost to lower income occupations, licensing pulls the first rung of the economic ladder up and out of reach for these people. For people who could earn some much needed cash on the side by being a physical trainer, or arranging flowers, or shampooing hair, or helping with moves, the effects are devastating. Now, Illinois is no exception. You're certainly not as big of an abuser as my home state of California, where you have to pay $375 to get a license to be a travel agent, or you have to spend $529 and 1,400 hours, that's 4 years of experience to get a license to be a tree trimmer. But you've got problems of your own. In this state, you need a license just to be a sign language interpreter, which, might I add, is the most burdensome licensing requirement in this state. You have to pay a $900 fee, pass 2 exams, and undergo 1,500 days of education. Now imagine if you grew up with someone in the house, someone in your family who spoke sign language, and you knew sign language, and you wanted to make some money on the side as a sign language interpreter. This would effectively shut you out from doing that. Illinois also licenses athletic trainers, makeup artists, masseuses, locksmiths, security guards, travel guides, and animal breeders. Now, the city of Chicago in particular was recently in the news for its effort to license pharmaceutical sales reps. Since July, anyone who wants to work as a pharmaceutical sales rep must pay a yearly $750 fee and take city-approved courses before being allowed to work, in addition to taking annual continuing education courses. Now, sales reps must also record every contact they've had with a doctor or any healthcare professional and note what drugs they promoted. They have to keep these records on hand and are expected to turn those records over to a government official whenever asked. The fines for working without a license, just in the city alone, can run up to $3,000 per day. And Chicago is just one of 2 cities in the entire country to impose this type of licensing requirement. The city said that the reason for this law was to prevent opioid abuse. But pharmaceutical reps don't actually sell drugs. They merely discuss them with doctors, and they provide literature and samples. And it's the doctors who later make their own independent decision of whether to prescribe a particular drug. And it's the pharmacies that actually sell these drugs. And that whole process is already extensively licensed by the FDA. If the city is concerned with this deceptive marketing processes or something else that would lead to opioid abuse, it should actually outlaw deceptive marketing abuse. It shouldn't just impose a burdensome licensing scheme that keeps people out of jobs. So licensing is often justified this way, right? It's justified as a public health or safety measure, as a way of ensuring that people are qualified for their job. But the problem is that in actuality, licensing is a drag on the economy that has no appreciable benefit to the public. Studies show time and time again that licensure does not actually improve the quality of services. So there was a study of dentists, for example, that studied places that license dentistry and others that don't, and it came out that licensure had no impact on patient outcomes whatsoever. Another study of mortgage brokers showed that licensure did not lead to any benefit like fewer foreclosures, but it did result in higher prices. So even the Obama White House came out in the last years of its administration and said that licensing has simply run amok. It is keeping entrepreneurs out of honest work without giving any appreciable benefit to the public. So the reason for this is that in large part, it's not actually motivated by a desire to protect the public. It's often instead requested by the industry players themselves who seek regulations in order to put up a barrier to new competition. Many times licensing will consist not of health and safety measures, but of anti-competitive nonsense that simply makes it harder for people to enter a trade. So there are cases, and these have gotten a lot of attention, where licensing boards have tried to make African hair braiders get a cosmetologist license, even though the training or education for cosmetologists has nothing to do with African hair braiding. Or I had a case in Oregon where the Oregon Board of Architect Examiners argued that our client needed an architect's license simply to make what were in essence pretty pictures. Our client drew marketing drawings that were meant to attract potential investors to hypothetical developments. They weren't plans. They would never be used for plans. In fact, if the development went forward, they would hire licensed architects to make these plans. And yet the Oregon Board of Architects said that you need a license to make pretty pictures because they don't want competition for ancillary services. In fact, they regulated their authority so expansively to say that, quote, any activity done in contemplation of erecting a building needs an architect's license. It doesn't protect health or safety to make people that are making pretty marketing pictures get an architect's license. It's just an anti-competitive attempt to keep people from competing with licensees. One of the most egregious examples of laws that have no relationship to protecting public safety and instead stand as a simple anti-competitive barrier to entrepreneurship are competitors' veto laws, which essentially require entrepreneurs to get permission from the existing businesses before starting up. Over half of states have these laws, and they exist mainly in the transportation industry, if you think moving companies or taxis and limousines. And each state is different, but West Virginia's former law stands as a pretty representative example. So the way that West Virginia's law works is that when you apply for a license to start a new moving business, you pay a fee, you provide your name, the type of service that you want to provide and where and what equipment you have. And then you have to give notice to all of the existing businesses. Then the existing businesses are offered an opportunity to protest your application. They can protest on any basis, including the basis that they simply don't want to compete with you. If a protest is filed, the applicant has to attend a hearing where they must prove to a bureaucrat that their business is somehow necessary. Now, what that means is difficult to say because there's no regulations within the law that show how you could prove that. And in fact, it's almost impossible to prove in advance that your business is necessary. Typically, in America, the way that you show that your business is necessary is by opening your doors and seeing if the market sustains you. But in West Virginia, they leave it up to bureaucrats to determine whether your business is, quote, necessary. Worse, they often defer to the entrenched business's self-serving statements about whether they can service any existing public demand. So the existing businesses are entitled to show up to your hearing and testify that your business isn't necessary because they're fully capable of taking on any public demand. These laws have no relationship to protecting the public. On their face, they're not related to protecting the public. Even a fully qualified entrepreneur who would provide services at a reasonable rate and do it safely must be denied a license if they can't prove that their business is necessary because the existing businesses say it's not. And the stories of how these laws affect people are just heartbreaking. Our client, Artie Vogt, was the owner of Lloyd's Transfer and Storage in Virginia, but it was close to the West Virginia border. He had licenses that allowed him to work within Virginia and to do moves across state. There was no doubt that he was fully qualified to run a moving business. In fact, his company had been operating for something like 100 years. He started there after college as a driver and slowly worked his way up and saved up enough money to buy the business with his wife, Stephanie. What he didn't know was that when he bought the business, the license to operate did not transfer with the purchase. So all of a sudden, he didn't have legal authority to operate in West Virginia. So, of course, a competitor complained to the regulatory body that he was operating without a license. He didn't even know. He got a cease and desist order that said, you don't have authority. And he completely stopped operating and said, okay, we'll apply for a certificate of need, or what we call the competitor's veto. And, of course, he was denied on the basis that his business, which had been in business for 100 years, wasn't, quote, necessary. So we sued on Artie's behalf. And what we found during discovery was that no application to operate as a new moving business had been granted in the past 10 years. Every application for a new business had been protested by an existing business, and for those that decided to continue through the process rather than giving up, they were all eventually denied after months of going through the process, and in Artie's case, after spending nearly $10,000. So we've sued to challenge competitors' veto laws, or what are also called certificate of need laws, in 7 states, and we've seen the same type of thing each time. So in Missouri, we had a lawsuit, and we found that over 5 years, there were 106 applications filed for permission to operate statewide. There were, every application was protested by an existing business. Every application was protested on the basis that the business wasn't necessary, and all of the applications were denied except for a handful on the basis of competition. What's interesting is that if an applicant went ahead and amended their application and said that they only wanted to operate in some rural part of the state where there were no other operators, the protests were withdrawn and eventually the certificate was granted. But if they ever threatened an existing business and decided to continue through the process, they were denied the certificate. So you can see from the way that these laws play out that competitors' veto laws don't benefit the public. They harm consumers who suffer higher prices and decreased quality due to a lack of competition. It's plain from the way that these laws work in practice, that they are designed solely to favor entrenched businesses. Now, fortunately, the Constitution protects economic liberty. The 14th Amendment protects our precious right to earn a living free of arbitrary and irrational government interference. So the Supreme Court has held that the government can impose licensing requirements related to health and safety, like requiring doctors to have training in medicine. But it can't exclude people from occupations for reasons unrelated to their qualifications. So it can't, for example, prohibit somebody as working as an attorney because of their political beliefs. So when government burdens economic liberty through occupational licensing or other regulations, we sue. We sued in Artie's case, and thankfully, the legislature repealed its competitors' veto law soon after. The same is true after we sued in Oregon, Missouri, Montana, and Pennsylvania. And before the legislature was able to moot our case, we were able to score an important victory in federal court in Kentucky. So if you're interested in this issue, I've brought an advanced copy of my forthcoming paper here that's called Curbed. Everyone should have a copy on their table. And it documents the states that have these certificate of need laws, or what we call competitors' veto laws in the transportation industry. It does a nationwide survey, and it tells the story of our clients who have faced the competitors' veto and have managed to come out ahead. The hope is that with more awareness, we can get rid of these laws in more states and unleash entrepreneurs to compete. The last thing that I want to say is that in addition to the practical effects of licensing, on a philosophical level, this type of government regulation turns on its head one of our country's bedrock principles. That is, our Constitution provides for a system of government wherein people have the liberty to do what they want to do, to determine what makes their lives meaningful and to pursue their conception of happiness, with a limited exception for the federal government, which has limited enumerated powers, and with a state police power where they can enact laws related to health and safety. But now the assumption is just the reverse. If you want to build on your property, if you want to change your kid's school, if you want to get a job, etc., you don't have the liberty to do what you want to do subject to exceptions. You actually have to ask the government for permission first. You need a permit to do whatever it is you want to do. And our property rights cases can get pretty egregious. You have to get a permit nowadays, particularly in California, where I'm from, not only to build your dream home, but also to just refinish your pool or to repair old stairs or to put up a seawall to protect your home from further damage. And this shift from the presumption of liberty to a presumption of regulation is no small shift. It's a fundamental shift. It's a fundamentally different way of envisioning your place in the world and your relationship to the state. So the last example I want to give of one of my cases is a First Amendment lawsuit brought on behalf of beloved Bay Area bookstore Book Passage and its colorful owner, Bill Petrocelli. So Book Passage is a hub of literary activity in the Bay Area. They frequently host author events wherein authors come and they sign their books. And Book Passage doesn't charge for this. I mean, you just pay the cover price of the book. And it's a way for Book Passage to compete in the age of Amazon, rather than acting the way that most businesses do and seeking out regulation to stifle its competitors. It has instead decided to innovate. It holds over 800 author events a year wherein people can come and meet their favorite authors and get a book signed. So last year, California passed a law at the behest of Mark Hamill, aka Luke Skywalker, which expanded the state's autograph law. Formerly, the autograph law only applied to entertainment, sports memorabilia, but Mark Hamill warned the legislature that people were being swindled out of, quote, hundreds of dollars for fake Luke Skywalker autographs. So he insisted that, that the state enlarge its autograph law to cover entertainment memorabilia. Now, the legislature, in all of its wisdom, expanded the law to cover any autographed good worth over $5, which inadvertently swept within it books. So how the law works is if you sell an autographed item worth over $5, you have to provide a certificate of authenticity on steroids. Not only do you have to authenticate the signature, but you also have to include a litany of information, including if there's any potential sequels anticipated, how many editions there are. You have to include personal details about the sale, including the place of the sale, the time of the sale, a witness to the signing, the name and address of any previous owner, and a whole host of information on this little certificate. Not only that, but the seller has to keep a copy of that certificate for 7 years. Now, failure to keep the certificate for the full 7 years, or even making an inadvertent omission, subjects you to an inordinate amount of fines and penalties. You have to give up 10 times any actual damages in addition to attorney fees, interest, and any fees that the court deems reasonable. So this is a very burdensome thing for somebody like Bill, who holds 800 author events a year. It's a bureaucratic nightmare that he said would prohibit him from continuing his business. He simply can't sit there just from a practical standpoint and offer this sort of certificate of authenticity to every person who comes in line to have a book signed. And I think this is a very good example of the way that the presumption has been reversed from you can live your life and you're able to protect yourself. If you want to authenticate your signature, go ahead and do it. If you want to pay for that, you have the right to. No, the government's going to mandate that, and you don't even have the ability, if you'd like to protect yourself because it's required. You don't get to choose the level of protection or whatever. We force this cost on the seller and presume that you don't have the ability or the right to protect yourself. So what's the upshot of all of this? I think the upshot is that change is coming. With our competitors' veto cases, almost always now when we go into a state and sue, we see immediate legislative victory. With Bill's case in the book passage, we brought a lawsuit arguing that the autograph law violated Bill's First Amendment rights because it burdened his ability to distribute books, and autographs themselves are communicative pieces that are protected by the First Amendment. And the legislature shortly thereafter passed a repeal bill that limited the autograph bill so that it no longer applied to books. So change is coming, and I think with more research, people are second guessing their assumption that licensure is good. We have a bipartisan coalition that agrees that licensing is simply run amok. With lawsuits, we're seeing legislative repeal and court victories, and we're also seeing systematic changes. We're not just seeing many changes in responses to our lawsuits, but we're seeing efforts at the state level to enact systematic changes to prevent this type of abuse from happening. So we see sunrise provisions where it makes it more difficult for states to enact licensing laws. They actually have to do some research and figure out if there's any harms being done and if the licensing laws would relate to preventing those harms. And then there's sunset provisions that say that every 5 years the state has to evaluate their licensing laws to determine whether they're really necessary. So we're seeing a lot of change, and that's important. But I think that it's going to take a cultural shift that recognizes first that economic liberty is important and shouldn't be relegated to some second-tier right because it's central to our pursuit of happiness. And secondly, that the road to hell is paved with good intentions, that even though some of these laws might be enacted with the best of intentions, oftentimes, like in our book passage case, the legislature isn't very good at fixing them. And third, that with licensing, sometimes there aren't good intentions. It's regulatory capture for the benefit of industry insiders. And if we want to keep the American dream alive, we have to make it easier for people to earn a living in the occupation of their choice by establishing meaningful limits on the government's ability to stifle that choice. Thank you.
Great, thank you very much. Wait for this microphone to come on. And I think it's on now. There we go. Excellent. So now it's time for Q&A. And by the way, after tonight's event, I'll be providing autographs at the table right there. But I don't need a license because they're definitely not even worth $5. Proof I was listening. All right. So if you have a question, please raise your hand and identify yourself so that Anastasia knows to whom she is speaking, and a microphone will come to you. We will start right here. And if you're online, I'll be watching on my phone. If you want to leave questions either on Facebook or YouTube, I'll be reading them over the air. We'll start right here.
My son is an artist, or was an artist, excuse me. His works are being held in San Francisco. I'm in the process of producing a book, a catalog of my son's work. He committed suicide in Missoula, Montana, producing where he produced most of his artwork. I'm running into a lot of stumbling blocks on being able to produce a book with all of my son's work. Have you ever handled a case concerning artists?
I think the closest I've come is probably with regard to our architecture lawsuit, where our client was simply making what we called pretty pictures. But there, we didn't make a First Amendment argument because we were taking the case over on appeal. And so the attorneys below hadn't made that argument. But certainly, I think it's important. I think it's particularly dangerous where we see the government regulating in fields that have a strong First Amendment side to them, where it's professionals who maybe are just talking. They literally just talk for a living. I mean, you could think of travel agents or tour guides, people who just talk. Right, exactly. And also artistic occupations, you know, photographers, architects, artists to some extent. And fortunately, when we take those cases, those get heightened protection. So courts tend to like First Amendment cases. First Amendment cases, great, a lot easier to win. Economic liberty cases, just a straight 14th Amendment economic liberty, no First Amendment aspect. They don't take very kindly to those. So it's a great place to litigate. I'm certainly interested. It makes it easier to win, and we're always happy to have new cases at PLF.
We have one right here.
My name is Carl Lambrecht. In Highland Park, Illinois, I asked if someone could operate a push cart in the city selling hot dogs or whatever food they want from there. I was informed, yes, you can. On the 4th of July, they have an event, and in one area of the center of town, you can get a license to vend food, but at no other time, because this affects the business of the brick and mortar business. And I said, this doesn't make sense. And I said, the fact that you have a license for just that one day, maybe the other days don't need a license at all. And what can be done?
Yeah, that's interesting that they took that hard line that it is simply anti-competitive, because usually states will bend over backwards to come up with some other excuse, because an anti-competitive law that's there for the sake of being anti-competitive is, of course, unconstitutional. So they'll make up all sorts of absurd excuses that have nothing to do with the regulation, but they say that's what the regulation is doing in order to avoid any sort of appearance of being anti-competitive. So in our competitors' veto cases, they'll say, well, we need these competitors' veto laws because we need to keep cars off the road to preserve the roads. They won't tell you that the law is intended to do exactly what it does, which is just keep competitors out of the industry. But in any event, when governments do that, when they do enact laws for the sake of protecting the established businesses, and this happens a lot with food trucks, right? They say that food trucks can't park 150 feet in front of any brick and mortar establishment, specifically for the purpose of protecting those establishments from competition. When they do that, those cases are ripe for challenge. That's certainly an issue we want to get to the Supreme Court, which is that the government can't use its licensing power simply to favor some politically powerful group.
Put your hand up if you have a question. Got one right here.
Hi, hello?
Yes, go.
My name's Dan Robin. Can you speak to the progress on reciprocity among states for licensing?
Yeah, absolutely. That's been a big movement as awareness has come about occupational licensing abuse. There's a movement to have reciprocity so that people who are already trained and certified by some state, and there's no doubt of their qualifications, can work somewhere else. And part of that's come about because the reciprocity problems, the people that it harms most are military families and other people who move frequently. If you're a military family and you're forced to move states, the military spouse can't get a job in the new state, or they have to go through this crazy licensing procedure in order to get a license there and to have a new job. And so as there's been awareness of this problem, of the way that it's impeding all people from moving across states, there's certainly been an effort for reciprocity. We see it even now in the legal profession, that they're trying to maybe have a more standardized bar requirements so that you can work in another state if you have to move for some reason.
We have a question right over here.
I'm Diane Bast here at Heartland. Tell me about dog sitters and why dog sitters need a license, and in how many states, and what possible rationale do they have for that?
Yeah, well, it's interesting. That was big in the news recently in New York City. They were trying to impose a dog sitting license. I think a funny fact in that case is that they don't require a license to babysit, but they do for dog sitting. So maybe they have their priorities a little off. But it came out, of course, that the dog sitting license effort, of course, that was a response to Rover. Rover's a business. It's part of the kind of the sharing economy. Like it's Uber or VRBO, and it's an app that easily allows you to just bring your dog to somebody's house that's in the neighborhood. And the kennels didn't like that. And so they tried to impose a licensing requirement, which would price out all of us people who just want to, babysit a pet for a couple bucks on the side. So that's the real motivation. I don't think they have a good health or safety argument, particularly because there's ways of dealing with that actually relate to health and safety, like saying you can only have so many dogs, or you have to submit yourself to health and safety inspections. But no, they want to impose this crazy licensing requirement, and it's exactly because they want to price out competitors to kennels.
We have a question right here.
My name's Larry Greenberg. This is just a question. To what extent do local governments and even state governments want to impose these regulatory regimes to get the fees? Is it substantial, or is it nickel and dimes?
Well, it's certainly something that arose with regard to Chicago's effort to license pharmaceutical reps. That was going to rake them in something like, anticipated millions of dollars per year just for that licensing scheme. And I think it's reasonable to assume that that's a big motivation. These fees a lot of times aren't related to the cost of enforcing safety violations. They're arbitrary fees that can be really high. I mean, there's no reason you should need $1,000 to get an interior design license in the 4 states that require it. So I think it's reasonable to assume that that's a problem. And fortunately, there has been some efforts on state levels to prevent localities themselves from imposing additional licensing fees, because then you can't even move within the state. Not only can you not move to another state if you have to because you can't get a job there, you can't even move within the state because each locality now has its separate licensing regime. So Wisconsin just last year had posed a law saying you couldn't do that.
Food trucks, I know this from family business. Food trucks, to get a license in Chicago is expensive, not to mention the capriciousness of the inspectors who can make or break your business. But then if you ride across the line to Evanston or to Glenview or to Des Plaines, you need other licenses, and it just makes business just untenable.
Yeah, and it's interesting to see, between state to state or city to city, how these licensing laws play out. A lot of times, the level of restrictiveness depends on the strength of the lobby. So when we were in Montana and we brought a competitor's veto case for a shuttle company, we were able to get repeal for shuttles, which was great, but it turned out that the moving companies had such a cartel there and they were so powerful that we weren't able to get reform for the moving companies. So it's interesting to see state to state which laws stay on the books because of which cartels are strong.
Please raise your hand if you have another question. I'm going to read one here from the chat room on YouTube. Weather Dynamics is the handle, so hello. Welcome to the event tonight. And this actually goes to something I was going to ask you as well. What is the easiest way to convince people that licensing laws are out of control?
Yeah, I mean, I think there's 2 things. One is pointing to these crazy examples like shampooing hair. I mean, you point to an example of things that people can do from the comfort of their home that don't prevent any threat to public safety. So, and there's plenty of them. Shampooing hair, makeup artists, locksmiths, just things that just are crazy. But another way is, thankfully, there's a lot of research and information coming out and studies that give us hard facts about how licensing plays out. And when we can point to the facts and say, hey, they claim public safety, but there's no evidence that this is giving any consumer a benefit, that it's leading to improved services, I think that's very helpful. And that's certainly part of our aim at PLF now, is not only to bring lawsuits, but to generate studies like the one that we have that put facts out there that show people how these licensing laws play out in real life and that contradict people's basic assumptions about licensure.
Right here.
David Perenboom, assuming, I know the answer to this, but I'll ask it anyway. Probably a lot of this is politics, and it is about campaign donations. Do you run into that a lot?
Yeah, I mean, the studies show that the people who lobby for licensing laws aren't people who are aggrieved in some way by a bad actor. It's the industry players themselves. It's the taxi companies who lobby for strict regulations to keep out Uber. It's not the public who wants to keep Uber out. It's the taxi companies. The public wants Uber. But you have very powerful cartels that are in place and don't want to see their monopoly threatened.
We have a question here in the back.
Do you see any opportunity for litigation around clinician licensing, medical licensing?
Well, ideologically, certainly it's appealing, especially as you get new and innovative services that shouldn't require the same type of licensure as actual doctors, like outpatient procedures or. I was speaking with somebody earlier about hearing aid fitters, and nowadays you just need an app to fit a hearing aid. So I think it's appealing, but the problem with that is that courts give such short shrift to economic liberty that if there's any colorable health or safety rationale, they just run away from it. It's very difficult to win any case where there's a colorable health or safety argument, or where courts think, ugh, medical, I don't want to get involved in that. That sounds scary. I don't want somebody to die because I struck down this licensing law. So maybe as economic liberty sort of makes a resurgent in the courts, and we try to give it the same level of protection as First Amendment cases, maybe courts will be more willing to actually scrutinize a law and determine if it's necessary. But for now, we find that courts are just very wary of doing that.
Another question back here?
I'm sorry, another question. When you are fighting these licensing laws in just kind of the public square and media, do you ever talk about the possibility of private alternatives? I mean, I could see an organization for licensing or certifying dog sitters or something, and that's kind of the private alternative to government licensing.
Certainly that's helpful in the debate, is to say, hey, we're not saying make it a free-for-all, that there can be no regulation whatsoever, but licensure is the most onerous type of regulation, and there are alternatives that are still regulatory, but there's a sliding scale, right, where that maybe you could have registration with the government, or maybe you could have mandatory certification by a private agency. Or, Uber's a fantastic example because almost everyone has used it, and they know that through technology we're really able to police ourselves, or police bad actors. You get immediate feedback about how good a driver is, and Uber knows how good a driver is because of your rankings, and they're very strict about if you don't have a good ranking, they're going to kick you out as a driver. So I think using Uber is a very helpful example to show people that it's not going to be crazy people getting injured everywhere if we lessen regulation, because technology makes it possible to do it yourself.
Yeah, we talked about that earlier on the podcast, and if you told anybody in this room 5 years ago that you'd grab your phone and a stranger would come pick you up, and there'd be a little icon telling you he'd be there in 4 minutes, he's going to take you anywhere you want at half the price of a cab, you would say, well, certainly government must have made that safe, right? I mean, there's no way the market can make it so that it's safe. This is dangerous. You can't have strangers picking up strangers. It's dangerous for everybody. But the fact is that the market made it so that it's not dangerous. It's very convenient, and it's cheaper, and it's better because the market has done that. And if the cartels, you talk about all these cartels, the closed gardens cartels, whatever you want to talk about it, in any industry, if they saw this coming, they would have done something to stop it. And so my question is, with Uber and Rover, I hadn't heard of, and that's fantastic. I might get on there. My house I got a room in my house for a couple dogs. I'll tell you that too. But so when you look at the horizon, where's the next area where technology may, supersede the idea that we need occupational licensure, or is it so bad that every profession possible and conceivable has already been regulated to the point of licensure where technology will not be able to overcome that kind of stuff?
Yeah, well, certainly we're seeing an expansion of the sharing economy into things that you would never even imagine before. I mean, Rover is a good example, or, trading clothes with people, or, all these really interesting ways for people to make money on the side, where, department stores would have interest in keeping the trading clothes economy underground. So it's hard to know where it's going. I think the fortunate thing is that when these things rise up, for one, they don't usually fit the perfect model. So when Uber rose up, it actually, the states actually had to affirmatively enact new laws to keep Uber out because they didn't fit into the traditional taxi definition. And so fortunately, they were able to at least start up, and then people really liked it. The taxi industry came back and lobbied for regulations to keep it down. But they were able to win in the court of public opinion, so now we see them operating in most states. But in any event, I think hopefully as these new innovative services come, they'll at least see the light of day, and then maybe there'll be a fight later about whether it's possible to regulate them out. But on the other hand, I think in the meanwhile we are seeing a lot of lost services. We were talking about this earlier. There's unknown unknowns. Businesses will never know. We'll never know if they could have come to light, but if they were stifled out due to regulation, because the entrepreneurs just never took the chance because they didn't have the means to get past the licensing law, or didn't want to go through, jump through the hoops to have to try it.
More questions from the audience?
One of the abuses that I see with especially state licensing of, quote, professions is that once you have your initial license, it's not forever. You have to recertify in some way prescribed by the state for a substantial fee. And I've seen this, for example. There are retired doctors, for example, who don't want to pay the fee and spend the 3 days, traveling to God knows where for this course, and so that essentially forces them to retire.
Yeah, it's interesting because I think nationally the trend is for states to reconsider their licensing requirements, but I had recently written an article about Baltimore, which in the face of all of these states actually lessening licensure laws, they just enacted a continuing education requirement for cosmetologists. So now on top of all the crazy licensing requirements that you have to do to even get into the business, now you have to recertify every so many years by taking, state-approved continuing cosmetology courses. And I argue in the article that, to the extent that consumers think that's beneficial, they should be free to choose cosmetologists who do that, and they'll probably pay a little bit more for it, and that's beneficial to the cosmetologists themselves and good for the consumer to get what they want. But it makes no sense to impose that mandatory requirement on people who may not want, who may not care, perhaps would rather pay lower prices in order to have a cosmetologist who didn't go through all those extra requirements. It makes no sense to do that when there's no evidence that it's even improving outcomes for consumers.
We have a question back here. Gentlemen, please identify yourself.
I'm Joe Bast. I'm with the Heartland Institute. I've got a couple of questions. Illinois has a regulatory sunset law. Are you familiar with it by any chance?
I'm not familiar with Illinois in particular. I am familiar with California's. California itself has one, but of course in practice sometimes they tend to be pretty weak. It's just a rubber stamp.
Yeah,
so it varies from state to state if they actually have any teeth.
Yeah. So as you were talking, I was reminded that this had come up, and Heartland has done probably some op-ed pieces on this over the years, but it passed in 1998. And so I just Googled it, Illinois Regulatory Sunset Law, and sure enough, the legislation comes right up. And it says here that on January 1st, 2018, the following acts are repealed: the Illinois Petroleum Education and Marketing Act, the Podiatric Medical Practice Act, the Illinois Speech, Language, Pathology, and Audiology Practice Act, the Interpreter for the Deaf Licensure Act of 2007, the Nurse Practice Act, the Home Medical Equipment Act, the Marriage and Family Therapy Licensing Act, the Nursing Home Administrators Licensing Act, the Physician Assistant Practice Act. So apparently all of these will expire in 2 weeks unless the Illinois State Legislature passes a law that renews them all. And I don't think anybody in this room knows if the legislation was taken up, if they voted on that. This would seem to be a great point of entry for activists to go in and talk to their legislators and say, let's let all this legislation expire. Sunset.
Absolutely, and a good model for other states. And certainly, then we can point to you when you can be the experiment, and when people aren't harmed by the repeal of these licensing laws, we can point to Illinois and say, listen, there wasn't, deaths everywhere from unlicensed family therapy. People are doing just fine. So that's a great point.
And a follow-up question. So Heartland could dog sit here? You don't know Illinois laws well enough, but if we were to take out an ad that said if you need somebody to take care of your dog for an hour or two while you're going grocery shopping, just drop them off at the Heartland Institute. I think Heartland staff would be happy to do that. Do you think that's probably against the law?
When I was perusing Illinois' licensing laws, dog sitting, I didn't see dog sitting, so it might be legal here. That's a good way for the Heartland to make some extra money.
If not dogs, kids. We could open a daycare center, since that's less regulated than dogs, apparently. All right.
Okay, I have another question here, and then we'll take a couple more from the audience or wrap it up here. So, Anastasia, what is the next big case that you are going to win that's going to change the world and change the law and wake the public up to these asinine laws that restrict our freedom, raise costs, and make no sense?
Well, the Supreme Court has said that license requirements actually have to bear on somebody's capacity to work in that industry, they've never actually explicitly said that stifling competition for the sake of stifling competition is not a legitimate use of a state's police power. So believe it or not, even though that seems self-evident, and it seems to sort of follow from that Supreme Court precedent, there's a circuit split amongst the circuits on whether states can use their licensing power just to dole out favors to politically favored groups. So what we want to do is get that issue up to the Supreme Court and set the precedent clearly that says that states can't use their licensing power in this way. And I think one of the best ways to do it is through these competitors' veto cases, because in those cases, there's no argument that those laws are related to anything but stifling competition. They don't protect health and safety because even the best operators must be denied if they're going to compete with the existing businesses. So it's my hope to continue our competitors' veto cases and hopefully get one of those cases up to the Supreme Court. The problem is nowadays when we go and bring these competitors' veto cases, people are just astonished. They can't believe that these laws exist in America. And so we get legislative repeal, during the same term, which is great. It's excellent. I'm happy that another person is, that more people are free after that. But, it'd be nice to actually litigate that case and get that precedent that will, protect other entrepreneurs in the future.
I have a question here.
Has class action ever been applicable? Any class action lawsuits?
I'm certainly not opposed. The problem is, it's not really a problem. It's just a fact, is that PLF is a nonprofit organization. We represent everybody for free, and we can only represent those people that can't afford to represent themselves. So we vet our clients very well to make sure that we're bringing a case that would otherwise not get brought without our help, and that has clean facts so that we're not going to get caught up in any sort of procedural messes, and that will allow us to just litigate the heart of the issue, the important issue that needs to be set, the precedent that needs to be set for the public interest. So we just have to be very selective. We can't represent everyone. But certainly, I don't think we're opposed to class actions. It's just a matter of figuring out when it makes sense.
More questions? Right here.
What's the mission of the Pacific Legal Foundation?
The mission of the Pacific Legal Foundation is to set precedent that brings teeth to the Constitution's protections for individual liberty. So we do that through cutting-edge litigation, through research and putting information out there to change the hearts and minds of the public, and to get momentum going that eventually leads to those wins in the court. And also when we can, we certainly are happy to testify to legislatures and also to get them to recognize what they're doing is unconstitutional. So broadly, it's to promote liberty. That's what we're there for. We do specialize in certain practice groups. We do a lot of property rights work. We do economic liberty work. We do some school choice things. We take a balanced approach to environmental regulation. But our mission generally is just to enforce the Constitution's guarantees that allow you to pursue your conception of happiness.
Time for a couple more questions. We've got one again right here.
Many organizations, for tax reasons, call themselves 501c3 or some number like that. And basically, they're afraid of the government because they may lose their tax-exempt status because of this. And this somehow is in the same general category, except it's the government that's abusing.
Yeah, so PLF is a 501c3. We do have that recognition. There is a lot of litigation. We don't have any cases related to it, but there is litigation ongoing related to cases in which the IRS and other authorities have targeted tax-exempt organizations for their political beliefs. We think a related issue would be in California. The AG now wants 501c3s to disclose the names of their donors, which we don't want to do that because we think that that's private information and we shouldn't have to. So there's litigation related to that also. But at PLF, we don't in particular take those cases, but certainly we understand that it's a problem.
And how might people anonymously donate to PLF and otherwise get a hold of you and your fine organization?
Yeah, and I should say we've written amicus briefs in those cases supportive of donor privacy. But if they are interested in anonymously donating to PLF, they could visit our website. They could follow us on Facebook or on Twitter. At Pacific Legal is our handle. Read our blog, which is on our website. Sign up for our newsletters. We're happy to tell you about all of the very exciting, very important cases that are always ongoing, and appreciate any support to represent these people who can't afford to represent themselves.
A round of applause for Anastasia Boden. Well, thank you all. You're welcome to continue mingling. It's the tacos might be getting cold, but they're probably warm enough to have one more on the way out. Thank you all for being here. Merry Christmas, Happy Hanukkah, and Happy New Year, because Heartland will be back in 2018 with even more events, so keep an eye on heartland.org. Thank you all for being here.